Case number 2 of 2023, Uganda versus Nandutu.
May it please my Lord. My name is Jonathan Mwaganya. And Mr. Nalera John.
Made before me, seeking for orders that 1, a reference be made to the Constitutional Court under Article 137(5)(b) of the Constitution for the interpretation of Section 21A of the Anti-Corruption Act 2009 as amended, and that the criminal proceedings be stayed pending the determination of the reference by the Constitutional Court. The background to this application is as follows. That the accused first appeared before the Magistrates Court at the Anti-Corruption Division on 9 April 2023, where she was charged with 1 count of dealing with suspect property, contrary to Section 21A(1) of the Anti-Corruption Act 2009 as amended. She denied the charge and was promptly committed to the High Court for trial. Consequently, she appeared before this court on the 3rd of May 2023 and pleaded not guilty to the same charge on indictment, following which the matter was fixed for trial on the 25th of May 2023. The particulars of the indictment to which she pleaded allege that between the months of June and July 2022, at the office of the Prime Minister's stores in Namamve and in Kola Cell, Bulwanyi Parish, Mukono Municipality, Mukono District, the accused person dealt with government property, to wit 2,000 pre-painted iron sheets of gauge 28 marked Office of the Prime Minister, by receiving and holding the said iron sheets, which she had reason to believe were acquired as a result of loss of public property, an offense under Section 10(1) of the Anti-Corruption Act 2009 as amended. When the matter came up for hearing, counsel for the accused submitted that following their close scrutiny of Section 21A(1) and 2 of the Anti-Corruption Act as amended, which they found to be broad, vague, imprecise, they were under instructions to ask this court to refer the following question for constitutional interpretation, and I quote the question as it was framed. Whether Section 21A(1) and 2 of the Anti-Corruption Act 2009 as amended by the Anti-Corruption Act number 21 of 2015, under which the applicant has been charged, is inconsistent with or in contravention of Article 28(1) and Article 28(12) of the Constitution. It was submitted for the accused person that all penal legislation must be clear, must also be precise. They relied on the decision of Justice Mulenga in Charles Onyango Bo and Andrew Mujuni Mwenda versus Attorney General in Constitutional Appeal number 2 of 2002 to support that position. They submitted that contrary to the law, the charge against their client was vague, and as such posed a miscarriage of justice, as it did not guarantee a fair trial under Articles 28(1) and 12 of the Constitution. They referred court to the long title of the Anti-Corruption Amendment Act of 2015, which read as follows, and I quote, "An act to amend the Anti-Corruption Act 2009 to provide for mandatory confiscation of property of a person convicted of an offense under this act, to provide for the procedure for issuing confiscation orders and related matters." The creation of the offense of dealing with suspect property provides in Section 21A(1) that a person who deals with property that he or she believes or has reason to believe was acquired as a result of an offense under this act commits an offense. Subsection 2 provides that for the purposes of subsection 1, a person deals with property if that person holds, receives, or conceals the property. They submitted that the above provision did not define, first of all, what suspect property is. It was also ambiguous for providing that the property in issue should have been committed as a result of an offense under the Act, and that the ambiguity is demonstrated by the fact that the prosecution, in the particulars of the case, introduced yet another offense of loss of public property. Further, that when the long title is considered, the intention of the amendment was to provide for confiscation and other related orders in respect of properties of convicted persons. Hence, the impugned section comes into play where a person has been convicted of an offense under the Anti-Corruption Act and his property is supposed to be mandatorily confiscated, and another person holds it, receives it, conceals it, then that person becomes culpable under Section 21A. They submitted that Section 21A, B, and C give a clear picture and supports their argument that one can only be charged under Section 21A1 where there is a conviction and confiscation of that person's property follows. They submitted that the vagueness and ambiguity in the section in issue contravene Article 28(1) and 12 of the Constitution and cannot meet the guarantee of fair trial and principles of legality. That it was unconstitutional for a person to go through a trial when the provisions of the law under which he or she is charged are vague, ambiguous, broad, and imprecise. On the basis of the grounds advanced, they applied to court to refer the matter to the Constitutional Court for interpretation, and they framed the question as I have produced herein before. Lastly, they informed the court that they had filed a constitutional petition in the Constitutional Court canvassing the same issue. In their considered view, this did not bar them from raising a question for reference, and they cited the case of Honorable Sam Kutesa and two others versus Attorney General, Constitutional Petition 46 of 2011 and Constitutional Reference 54 of 2011 as a basis for the same. They stated that in that case, both approaches were used. The trial magistrate referred the question, and both the petition and the reference were heard and determined together by the Constitutional Court. The respondent's brief supply to the submissions was that the long title of the Amendment Act also reads, "to provide for other related matters," and therefore the provisions thereunder are not restricted to mandatory confiscation of property of persons convicted of an offense under the Act or procedure for confiscation orders. Further, that the Amendment Act cannot be read in isolation of the Principal Act. The amendment merely reinforces the main legislation. They submitted that there was no ambiguity or vagueness in Section 21A, and only a plain reading or understanding of its provisions is required. That suspect property was defined within the Act to mean property which the accused believes or had reason to believe was acquired as a result of a crime under the Act. That the offense under Section 10(1) of the Anti-Corruption Act of loss of property was included in the particulars for that purpose. They accused the applicant's lawyers of taking the two-pronged approach of filing a petition and then asking this court to make a reference as a fishing expedition and a move intended to derail the trial of the applicant. That having filed a petition, they ought to have sought a temporary injunction to stop the trial, instead of asking this court to refer the same question, which is already before the Constitutional Court for determination. They submitted that the case of Sam Kutesa and two others was distinguishable, that the Chief Magistrate at the time of making the reference was not aware that a petition had been filed. I was not able to verify that from looking up at the decision. They contended that the question framed for interpretation did not raise any matter for constitutional interpretation, that Article 28(1) of the Constitution is about fair, speedy, and public hearing, and the application was instead actually delaying the proceedings. Further, that Article 28(12) of the Constitution provides that except for contempt of court, a person should not be convicted of any offense unless it is clearly defined. Lastly, that Section 21A is very clear, unambiguous, precise, and therefore the application does not raise a matter that should be referred for interpretation, and that the application should be dismissed. Again, in a brief rejoinder, counsel for the accused stated that the intention of the long title to the Amendment Act is to provide the rationale or mischief which the legislature wanted to cure, that it is therefore a guide to understanding the enactment of Section 21A and its application, that the mischief sought to be cured is that of convicts trying to hide their property. In the instant case, there is no convict, therefore the act of prosecuting the applicant contravenes the principles of legality. They maintain that the act of the state trying to include another offense in the particulars still demonstrates vagueness. that there is precedent for filing both a petition and making a reference in the same matter. There was nothing therefore wrong with their prayer. It was made within the framework of the law. They emphasized that there had been no litigation on Section 21A, and they saw no point in having their client prosecuted for an offense which may be unconstitutional. They therefore prayed that the doubt they had on the interpretation and application of the impugned section needs to be cleared before the trial proceeds. They reiterated their prayers. The issues for resolution before this court are whether the question raised by the applicant warrants a reference to the Constitutional Court, and whether, having been notified that the applicant has filed that the accused has filed a constitutional petition on the same matter, this court should still refer the matter to the Constitutional Court for interpretation. The question of whether to stay, in my view, hinges on the resolution of the above two questions. Now, by raising this question, the applicant, counsel for the accused, is putting into question the validity of the charge under Section 21A of the Anti-Corruption Act as amended, as against Article 28(1) and 12 of the Constitution on the basis of vagueness and ambiguity. I will reproduce Article 28(1), which says, in the determination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. Article 28(12) provides that except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law. A trial court such as this is mandated by Article 137(5) of the Constitution to refer a question only where it is satisfied that it involves a substantial question of law, and the provision reads as follows, and I produce it, that where any question as to the interpretation of the Constitution arises in any proceeding in a court of law other than the field marshal, the court may, if it is of the opinion that the question involves a substantial question of law, and shall, if any party of the proceedings requests to do so, refer the matter to court for a decision in accordance with Clause 1 of this article. A number of decisions have confirmed this position of the law. In the case of Haji Yusuf Bagalia and another versus Damaniko Properties Limited and Attorney General, Constitutional Reference 20 of 2021, the trial magistrate had referred a question for interpretation where she expressly had observed in her ruling that she did not find any matter that required constitutional interpretation. The Constitutional Court, when dealing with that matter, guided that the magistrate was right when she stated that there was no matter warranting interpretation, and she therefore ought not to have made the reference. While referring the matter, the Chief Magistrate had observed that a court before which a request is made is not merely a conduit to transact the question or transmit, but must consider whether there is merit in the application and if it falls within the letter and spirit of the relevant parts of the Constitution. The court held that any court, before deciding to make a reference to this court, must first be satisfied that prima facie there exists a question for constitutional interpretation. If it comes to the conclusion that prima facie no such question has been established requiring the interpretation of the Constitution, then no reference should be made. And the independence of the court to do so has not been taken away by Article 137(5)(b). Indeed, the position that the court must refer the question once it is raised is no longer law, automatically transmitting it, that is. This is the same position of the Supreme Court in Ismail Serugo versus Kampala City Council and Attorney General, Constitutional Appeal number 2 of 98, where the Chief Justice Wambuzi, as he then was, stated that for the Constitutional Court to have jurisdiction, the petition must show on the face of it that the interpretation of the court is required. It is not enough to merely allege that a constitutional provision has been violated. In the case of Yusuf Bagalie, I referred to it earlier, the Constitutional Court further guided that the question for reference must be set by the court before which it arises. That Rule 18 of the Constitution, Petition and References Rules, provides so, that the parties should be included, but ultimately the court should have the final say as to the core question, which is the subject of the reference. That decision, in my view, emphasizes the role of the referring court and the fact that the court must first be satisfied that interpretation is required. It follows that the court cannot frame a question where it is not convinced that a matter exists warranting constitutional interpretation. In order to do so, it must therefore analyze the request critically while keeping in mind that the jurisdiction to interpret the Constitution is vested in the Constitutional Court alone. I've carefully considered Section 21A. I've also considered submissions of both counsel. I'm of the considered view that in order for me to find that there is a question for constitutional interpretation, I must be satisfied that on the face of it, the contended ambiguity or vagueness complained of exists. I've carefully considered Section 21A and I'm of the view that the wording of Section 21A under which the charges are brought are clear and understandable. I'm therefore not convinced that on the face of it there is a question for interpretation, and this is my reasoning. That when you look at Black's Law Dictionary to define vagueness and ambiguity, to look at Section 21A and consider Article 28(1) of the Constitution, the definition given or the wording of the section should be so unclear and indefinite as to not to give a person of ordinary intelligence the opportunity to know what is prohibited. That is it. When I look at the wording of the section, I believe that before I can refer it to the Constitutional Court, I must on the face of it be satisfied that there is ambiguity. And of that, I am not convinced. It is alleged that the section as it is will cause an unfair trial to the accused person. The principle of fairness within Article 28(1) is about equity and impartiality. I do not find how the application of Section 28 of Section 21A relates to that principle or violates it, the principle of a fair trial. I don't see the connection between the two. In the case of Uganda versus Atugonza Francis, Constitutional Reference 31 of 2010, it was held that an applicant must go further to show prima facie what violation is alleged and its effect before a question can be referred to the Constitutional Court. But the Constitutional Court in that same case observed that that reference had not been brought in good faith, but only to delay justice. In that matter, therefore, I took interest in seeing what the Constitutional Court was dealing with for it to come with that observation that the constitutional matter should never have been referred, that there was no constitutional matter actually. The court in that case of Atugonza was considering the following question: whether the charging of the accused under the Anti-Corruption Act 209, which commenced on 25th August 2009, for offences committed between December 2007 and December 2008 is consistent with Article 28, 7 and 12 of the Constitution. That Article 28(7) was prohibited the charging of an accused person of a crime which is founded on an act or omission that did not at the time it took place constitute a criminal offense. When the Constitutional Court was regarding that matter, they found that the accused had been properly charged, that the provisions of the Anti-Corruption Act had been clear and unambiguous, that it had been repealed and replaced the penal code provisions that existed before. It was on the basis of that finding that they disagreed with the principle that had been advanced, that a repealed provision is treated as past and closed, and then they held that actually the reference was not justified and had been made in bad faith. In other words, the Constitutional Court was saying that that matter should never have been referred to it. In the instant case, therefore, for the reasons advanced, I decline to refer the question raised for interpretation because on the face of it, I do not see anything warranting constitutional interpretation. As I had earlier said, I find the provision clear and understandable, and I do not see the connection with Article 28 of the Constitution in terms of the infringement. As part of their submissions, counsel for the accused informed this court that they had filed constitutional petition in the very same matter, and they obliged the court and provided it with a copy. I've carefully considered the same. I note it was filed on the 24th of May. Ground 3A of the petition raises the very same issue advanced before this court. I'm of the considered view that Article 137 creates two avenues for taking a matter before the Constitutional Court, either through the petition or a reference. Whereas it is not illegal to pursue both, it is in my view only prudent that in order to avoid a multiplicity of cases and clogging of the judicial system, an aggrieved party should choose one of the options. In this case, a petition has already been filed, referring the same question, which is already before the Constitutional Court for consideration, in my view, is unnecessary and amounts to a deliberate attempt to stay this particular trial. In light of the foregoing, therefore, I decline to halt the criminal proceedings against the accused in this court. I dismiss the application, and I would like to advise that counsel for the accused may, if they so wish, seek an application for an injunction from the Constitutional Court to halt these proceedings, because I believe that the Constitutional Court, being vested with the jurisdiction to hear the substance of the matter, is better placed to determine whether a grant of stay is justicious or not. That's the ruling of the court. So how do we take this going forward?
Your Honor, we still have two witnesses.
Yes.
Present. We can't be ready to proceed. My colleague wasn't feeling well, but I believe we can be here in an hour's time so that we proceed with the business here. I am also informed that my other colleague had another matter. We believe 1 hour can be sufficient for us to do.
Which other colleague?
My Lord, I'm informed my other colleague had another matter. So we would fully rely on the guidance of the court.
By your other colleague, are you referring to Bisamunyu, or? You see, the representation is fluid, I see. I don't know who's joining who at what time. So which colleague are you referring to?
My Lord, I can leave it at the request for 1 hour to put our house in order.
All right. Counsel for the defense, I don't know who is lead, or you will be addressing court how you wish, considering the numbers keep increasing. Yes?
We will be addressing you, my Lord. Ochieng Evans for the record, my Lord.
Yes?
We have had the prayer by the state. We are seeking your indulgence to grant us a shorter journey. We propose a week. Let's continue as a week. To enable us to organize and focus on the trial. We believe that will be sufficient for us to prepare, internalize the statements that were disclosed. We had, my Lord, taken that night. But we obliged with the decision of court. So we just need a small time to reorganize and we will be ready to proceed. Yes. That is my
Council for the State.
No, my Lord, people.
We also are grateful for the guidance given to this court following this decision. And it's true, the Constitutional Court is in a better position to determine at this time, after your decision, whether this trial should be halted or not. And the time you have given us will be for us, if you please. One, apart from reorganizing ourselves, we will also be in position to yes, reflect on your ruling, and if need be, make the necessary application to the Constitutional Court. But at the time you give us, or the time of the adjournment, we'll be ready either with the proceedings before you, or if there will be an order of stay with the order. So we seek indulgence. And we believe that at the manner in which this matter is a matter which is not bulky. It's a matter which we can handle with Jonathan in a short period of time. So I appreciate if you grant us that short journey to request.
Counsel for the State, do you have any reply to the
My Lord, I
application?
prefer to be guided by court. How we should.
You must have an opinion, surely.
But my Lord, that's the request. My Lord, our position is as before. So, our position is as before.
They said they want 1 week. You don't have anything to say?
We came ready, my Lord. Still, 1 week is not bad enough for us. Especially if that week is to prepare for the trial as opposed to the anticipatory extension of time. For the purposes that my land brother comes. Praise God.
So in essence, you don't have an objection to the 1 week?
No problem.
All right, I omitted on the date that we were last in court to indicate expressly which way we were going. I said we were coming today to receive the ruling. And I do understand that that could have created the ambiguity of, shall we proceed, what's going to happen, are we ready or are we not? So for that reason, and also because Counsel for the State has no objection, and I think 1 week you're asking for is reasonable. But as again I said, if there is no order stalling these proceedings, we are going to proceed with the trial. So what you do in between is up to you. But if there is no order, by 1 week, we will proceed with the trial. June, Tuesday, 6th June is available. Monday next week, isn't that?
Monday is not. Monday is okay. Thursday and Friday are okay. So Monday, Thursday, Friday.
They're okay.
Okay with us. Monday, Thursday, Friday. Monday is not okay with me, but on Tuesday until the end of the week.
But Counsel, you said a week, and a week is exactly next week, Monday. And if you're not available, you have a panel of 3, 4 other lawyers.
I have some notorious practice of always practicing with this with Evan, and I'm lead counsel in this matter. So maybe Monday is not available for me. If Tuesday was available, Tuesday would have been okay for us. But Monday.
All right, so the case is adjourned for hearing on 8th of June, 2023. We shall start at 9 a.m. I'd like to, oh yes? Yeah, right. I know where you want to go with it. All right, the application is granted. 8th June 2023, we shall start at 9 a.m. I'm therefore extending bail for the accused person. Till then, you will get a copy.
Yeah, but I can.